Okay, so we've thought about the relationship of EU law to parliamentary sovereignty. We're now going to examine the relationship of human rights, or the Human Rights Act, to parliamentary sovereignty to continue our line of thinking. Let me make a couple of basic points which I want to then develop in detail. I think to understand the role of human rights in the British Constitution, we need to think about the political context. In other words, why it is that in 1998 we get the Human Rights Act. Now, the Human Rights Act was passed by the New Labour government. I'm going to make some references to the white paper in which the New Labour government explained why they were thinking of enacting a Human Rights Act. And I think this puts it straightforwardly and well. Let me just read it to you. Our aim is a straightforward one. It is to make more directly accessible the rights which the British people already enjoy under the Convention. In other words, to bring those rights home. To bring those rights home. Let's deal with that last bit, to bring those rights home. Just for ease of reference, I'm going to refer to this idea as domesticating the Convention. In other words, making the Convention part of domestic law. Let's take a step back to understand this idea. We are, of course, here referring to the European Convention on Human Rights. Now, the European Convention on Human Rights is an international treaty to which the UK is a signatory. It's drawn up just after the Second World War. It's part of the reconstruction, if you like, of Europe after the Second World War. And common lawyers, British lawyers, are instrumental in drawing up the rights in this convention and creating the international system which has the European Court of Human Rights at its centre. However, until 1998, when rights are brought home or rights are domesticated, British citizens could not make use of those rights in the domestic courts of the UK. What one would have to do is exhaust the domestic remedies that might be available to you and then take the United Kingdom as a nation to the European Court of Human Rights in Strasbourg. The point of one's argument would be that the country itself, the UK, is in breach of its international human rights obligations. So let's just pause here. Can you imagine the hassles and the expense of such a process? Exhausting all the possible domestic remedies in the domestic courts and then taking the United Kingdom's government to the European Court of Human Rights, at very least, a very expensive, stressful, time-consuming process. Now, the idea that the New Labour government have to bring rights home means that those rights are made part of domestic law. In other words, one can go into a UK court and make use directly in that court of one's convention rights. Now, again, we have to think this through a little bit carefully, because you might say, well, surely those rights existed already at common law. Well, the answer would be some did and some didn't. For instance, one of the important areas of development that we see in the wake of the Human Rights Act, after rights have been domesticated, is the growth of a law of privacy, which is, of course, incredibly inconvenient to the gutter press, to those newspapers that make a lot of money from printing pictures of celebrities, invading their privacy, if you like. The common law prior to 1998 had proved itself quite unable to deal with this matter of privacy, and the powerful commercial lobbies who still dislike human rights because it stops them making money, were quite happy with this situation, and are presently quite unhappy with the situation because they are bound by human rights. So my point in parenthesis here is that there's a lot of misrepresentation of human rights that goes on, partly because certain powerful interests don't like the fact that they now have human rights obligations. So if you're reading certain British newspapers with an anti-rights agenda, it's partly because it stops them making money. I think it's almost as crude as that. My point is here that the domestication of rights gives rise to the development of human rights principles and rules within the common law. And in certain areas, that makes a massive amount of difference. One particular area, the example that I gave, there are others, would be the area of privacy. How does this take us back to the idea of parliamentary sovereignty? I want to stress a couple of things that the Human Rights Act does. The main point that I want to stress is that the Human Rights Act preserves parliamentary sovereignty. What do I mean by this? The Human Rights Act does not give a British court the power to strike down an act of Parliament. That would, in other words, make the courts supreme. It would give the courts sovereign power because they would be able to override acts of the UK Parliament that were inconsistent with human rights. And that is not what the Act does. Let's be clear on this point. And let me read you again from the government's 1997, I think the date was, white paper, which relates to the argument as to why rights should be brought home, but why this domestication of rights should not limit the sovereignty of Parliament. So this is what the government says. It's paragraph 2.13 in the white paper. The government has reached the conclusion that courts should not have the power to set aside primary legislation, acts of Parliament, past or future, on the grounds of incompatibility with the Convention. This conclusion arises from the importance which the government attaches to parliamentary sovereignty. In this context, parliamentary sovereignty means that Parliament is competent to make any law on any matter of its choosing, and no court may question the validity of an act that it passes. In enacting legislation, Parliament is making decisions about important matters of public policy. The authority to make those decisions derives from its democratic mandate. Let's just reflect on that passage for a moment. We can see it actually goes back to the arguments that we have been thinking about that were developed by Dicey many decades earlier. Parliament is ultimately limited by its democratic mandate, and that is why the government wants to preserve parliamentary sovereignty. That is why the government does not want to create a Human Rights Act that would allow the courts to strike down acts of Parliament. This would, of course, empower the judges vis-à-vis Parliament. It would give the judges much more power. And so perhaps that is inconsistent with the idea in a democracy that ultimate power rests, if you like, here's the phrase, with the will of the people. Now, I think if one thinks in detail about this, the argument is, I think, slightly more complicated. One of the reasons why the new Labour government chose to pass the Human Rights Act, one of the reasons why we get this act in 1998 and not during the period of Conservative governments, is that this is a political activity. This is a political attempt to change the checks and balances in the British Constitution, which reflects in part the political understanding that Parliament has become too powerful, that the risk within the Constitution of a sovereign Parliament is that there are insufficient checks and balances on that Parliament. In other words, political sovereignty, the fact that a government could be voted out, does not in a day-to-day sense provide either sufficient limits on what Parliament is doing or indeed allow a thriving, developing public culture, a human rights culture, if you like. So what lies behind the Human Rights Act is a political choice, a political understanding of what was wrong with the Constitution. And clearly we exist within an era of British law where we still have a Human Rights Act. Now, I suppose one of the points that this begs is therefore what can the courts do with the Human Rights Act? One of the things that the courts can do is to issue what's called a declaration of incompatibility. Now, I'm not going to go into detail on this, but a declaration of incompatibility would be issued by a court if a government act, for instance, was in breach of convention obligations. The declaration of incompatibility would be, if you like, an invitation to the relevant minister to consider this fact, to consider the fact that an Act of Parliament was in breach of European human rights. It doesn't say that the minister has to change the law, because that again would bring to the end parliamentary sovereignty. If a judge could say to a minister, change the law, we've effectively redefined where sovereign power lies. What it is in effect is an invitation to change the law. In other words, the minister may choose not to. The second important thing that the Human Rights Act does is allow the courts to interpret British law in the context of the rulings of the European Court of Human Rights. In other words, this is giving the British courts the chance to develop human rights principles, to develop interpretations of the common law that are consistent with the European law of human rights. Again, this has proved politically quite problematic. I mean, one of the issues that has been in the news here has been the issue of prisoners' rights. There's been so much misinformation about this that I think it's probably difficult for me to talk about it in detail, but one of the pressing issues here is the question, I think, of where the balance of power lies in the Constitution. And I guess, as you might already have sensed, I am pro-human rights. I think that the balance of the Constitution is thrown out and that we actually need more human rights to protect citizens against powerful bodies within the Constitution. I can't go into those themes here, but the point I'm trying to stress, I think this is the important point that we should carry forward, is that the Human Rights Act does not limit parliamentary sovereignty. It gives the judges more powers of interpretation to make human rights rulings. It allows the judges to issue declarations of incompatibility, which invite a minister to consider the fact that an Act of Parliament is in breach of human rights obligations, but it does not give, the Act does not give the courts the power to strike down acts of the UK Parliament. In other words, we could perhaps see it as redressing some of the checks and balances of the Constitution, but we could not say that the Human Rights Act brings to an end parliamentary sovereignty.